okay, millions of Epstein files were released, all right, but nearly the same number are still missing. So Jamie Raskin is saying some well-known names that were already public, were still removed from the documents. Now, if everything was clear back in 2009, then why is so much still redacted today? Watch this clip. After it ends, we'll show you new information and explain what it means.
I saw the names of lots of people who were redacted for mysterious or baffling or inscrutable reasons.
Are any of them well-known individuals?
For example, Mr. Wexner, his name was redacted from a government document. And I couldn't understand the logic of that. He was not a victim, and his name has appeared other places. Now, the Department of Justice has not sent forth its so-called privilege log, so it's not explained yet why there might be certain redactions that have been made. I saw one document which was an email that was sent by Jeffrey Epstein to Ghislaine Maxwell, which was the forward of an email that he had received from some of his lawyers giving an account of a conversation between Epstein lawyers and Trump lawyers and others about what had taken place during that 2009 period. It was during the period of the 2009 investigation. And Epstein's lawyers synopsized and quoted Trump as saying that that Jeffrey Epstein was not a member of his club at Mar-a-Lago, but he was a guest at Mar-a-Lago, and he had never been asked to leave. And that was redacted for some indeterminate, inscrutable reason. I know it seems to be at odds with some things that President Trump has been saying recently about how he had kicked Jeffrey Epstein out of his club or asked him to leave, and this was at least one report that appears to contradict it.
What did you see specific to President Trump or President Clinton, and were there specific redactions to them?
Well, I just gave an example of one redaction related to President Trump. I did not see any redactions related to President Clinton.
What was the smoking gun in all this?
Well, I don't. Here's the thing: the Department of Justice is under orders from Congress to release the entire Epstein file. They released 3.5 million documents, and they've withheld 3 million documents. So about half of all the documents have not been released yet. Of the 3.5 million documents that have been released, I probably had the opportunity to review maybe 30 or 40 of them. Okay, so this is going to be an extremely time-consuming and painstaking process. The Attorney General and the Department of Justice have said that this process was something that was completed by them back in July. These materials could have been released long ago, but they're just being released now. And if every member of Congress who voted for the discharge petition, if all 217 of us spent every waking hour over at the Department of Justice, it would still take us months to get through all of those documents. And there are only 4 computers now, so they would certainly need to get a couple hundred more computers for all of the members. But the point is that there is no way before Attorney General Bondi arrives on Wednesday that we're going to have the opportunity to go through every redaction in order to ask thorough questions.
You think that's the connection, that they held up releasing this so that everybody wouldn't be as thoroughly prepared for her testimony Wednesday?
Well, no, I think that the Department of Justice has been in a cover-up mode for many months and has been trying to sweep the entire thing under the rug. And the more deeply that I get into it, because obviously our colleagues on the Oversight Committee have taken the lead, but judiciary plays a very important role because we oversee the Department of Justice. But the more that I've gotten into it, the more I believe that the survivors here, the victims who are now active citizens for justice, really are leading the way. And we need to be having hearings with the survivors, to hear from them about their experiences so they can explain what happened and so they can begin to set forth a theory of what took place. We need to be investigating the money. We need to be investigating the organizational hierarchy. There's no way you run a $1 billion international child sex trafficking ring with just 2 people committing crimes, Jeffrey Epstein and Ghislaine Maxwell. No way. It doesn't work like that. So we need to figure out what other conspiracies were involved, what other co-conspirators were involved. And I really do believe that listening to the survivors is going to be our pathway through this nightmare.
What is the next step for Democrats to take? You say there are obviously millions of documents, 4 computers. What is the next step? And in addition, what is the next step to get that other tranche of 3 million plus documents released?
Well, a lot is riding on Attorney General Bondi's appearance before us on the Judiciary Committee on Wednesday. We believe that this administration must listen to the survivors. We believe that this administration must release the entire Epstein file, which is compelled both by a congressional subpoena and by a federal law at this point. We want all of the information to come out, and the only redactions should be the names of the victims and the identifying information. Unfortunately, they violated that precept by releasing the names of a lot of victims, which is either spectacular incompetence and sloppiness on their part, or, as a lot of the survivors believe, a deliberate threat to other survivors who are thinking about coming forward, that they need to be careful because they can be exposed and have their personal information dragged through the mud as well.
Now, it's important that we focus not on emotion, but on what the record actually shows, what was said, what that claim is based on, and just as importantly, what is not visible. That is the real center of this entire issue. To start, we need to understand the 2009 investigation. At the time, the public narrative was that the Jeffrey Epstein case had been handled and that action had already been taken. But when you go back and look at the record, it becomes clear that the investigation was extremely limited in scope. It was not a full federal investigation, and it did not broadly examine international networks, funding structures, or potential collaborators. That does not mean wrongdoing was proven back then. It means many issues never entered the scope of the investigation at all. What often gets overlooked in that period is that in 2007-08, Epstein entered into a non-prosecution agreement that effectively narrowed the case to a limited state-level resolution. A later internal review by the Department of Justice acknowledged that this agreement halted a broader federal prosecution from moving forward. This does not establish guilt, it establishes context. It explains why the original investigation did not examine the full scope that later records suggest existed. This is where today's document releases become important. When millions of documents are now being made public, the obvious question is why? If everything was truly clear in 2009, then why does such a massive body of records exist today? And even more importantly, why are nearly as many records still not available? This is not an accusation. It is a numerical and procedural question. This is the point where what Jamie Raskin is saying becomes relevant. He is not claiming that any individual has been proven guilty. What he is pointing out is that the pattern in the records is incomplete. Some names that were already part of the public record that had appeared in media reporting or court filings were later redacted in released documents. The question is not why redactions exist. The question is why information that was already public is suddenly being treated as confidential. The volume of documents itself tells a story. The Department of Justice has said that millions of pages were released, while also acknowledging that millions of pages have not been released. When only half of the record is visible, any serious review remains incomplete. This limitation applies not just to the public, but even to members of Congress themselves. Another key factor in this process is access. When access to records is constrained by limited resources, limited time, and limited physical capacity, it becomes difficult to claim that the full truth has already emerged. This is not a claim of conspiracy. It is a logistical reality. The same issue appears when looking at the emails and legal communications referenced in the clip. The record shows summaries of certain emails and descriptions of legal conversations, but not the full communications themselves. That does not prove that anything unlawful occurred in those conversations. It simply means the full context is not available. And without full context, any evaluation remains incomplete. Asking questions in that situation is part of a democratic process. There is also a clear imbalance when it comes to redactions involving victims and non-victims. In some cases, identifying information related to victims became public, even though that information should normally receive the highest level of protection. At the same time, some non-victim names were redacted. This inconsistency raises questions, not to draw conclusions, but to assess whether the process is being applied fairly. It is also important to understand that this discussion is not centered on any single individual. It is about a system tied to large-scale networks, international movement, and years of activity. History and the study of organized crime show that operations of this scale do not function with only two people involved. That is why the issue of potential co-conspirators arises. Co-conspiracy does not mean guilt has been established. It means the scope of the investigation is not yet complete. So when claims are made that everything has already been released, those claims should be treated as procedural statements, not final conclusions. A conclusion can only be reached when the record is complete, when questions are answered through documentation, and when the process is transparent. In this entire context, the most reliable voices remain those who were directly harmed within this system, the survivors. Their experiences do not change over time. They are not part of political cycles. Their accounts align with the gaps seen in the record. That is why many lawmakers argue that future hearings must place these voices at the center. When we look at the clip and the surrounding records together, one point becomes clear. Questions are being raised because information is incomplete. Names are being discussed because patterns appear inconsistent. And further investigation is necessary because the process is not finished. This is not an attempt to assign guilt. It is an effort to ensure that when history is recorded, it is not incomplete. In matters of public record, asking questions is not a crime, and it is not sensationalism. It is a responsibility. If you found this analysis useful and want to see more record-based, calm, and clear breakdowns like this, consider subscribing to the channel. Your support helps us continue producing fact-focused content like this.